Hello, and thank you for joining us for the SLW Institute webinar, Recent Developments in Subject Matter Eligibility Guidance and Case Law. We will be recording the webinar today and sending a link to the recording and slides to everyone who has registered. We will also put a link into the chat to where the presentation slides are posted online. If you would like to ask a question, you can enter questions using the Q&A feature in the Zoom menu or in the chat. Our speaker today will be Kirt Iverson. Kirt is an intellectual property attorney and principal at SLW. He is a registered patent attorney with more than 15 years of experience. His education includes an MBA and a Master of Science in Engineering from San Jose State University and a law degree from Santa Clara University School of Law. And with that, I'll turn things over to Kirt.
Hello, everyone. I'm working in the Silicon Valley office of Schwegman, Lumberg, and Wussner. I've been working here since I graduated from law school at Santa Clara University. As you might imagine, a lot of my clients are software clients, and my expertise is in software. And subject matter eligibility is a big concern for a lot of my clients. And so I've become one of Schwegman's experts in this particular area of the law. What I'm going to do today is cover some of the recent developments in subject matter eligibility guidance and case law. I'm covering basically since the 2024 AI SME update for the guidance, at least. And for the case law, I'm going to go back about as far as Berkheimer. If you want interesting subject matter covered related to this, I have two other webinars that are posted on the SLW Institute that go back further. But this is more of what's happened recently. Just as an overview, the USPTO has issued guidance updates, 3 of them since the 2024 AI SME update. By the way, the 2024 AI SME update was effective July 17, 2024. So these are memos that were released since then. The August 4 memo gives some reminders to examiners about what they're supposed to be doing when they examine a patent application with respect to subject matter eligibility. The December 4 memos, there's 2 of them. They talk about subject matter eligibility declarations, or otherwise known as SMEDs, and best practices for SMEDs. And then 1 day later, the December 5, 2025 memo covers the Desjardins case. And this is a very significant case in recent developments. As far as the CAFC case law updates since Berkheimer, which was February 8, 2018, there's 21 cases finding eligible subject matter and 39 cases finding ineligible subject matter. And we're going to just touch on a couple of these cases near the end of the presentation. Let's talk about the August 4 memo first. This memo purports to provide guidance on the following topics that arise when examiners assess Step 2A of the USPTO subject matter eligibility analysis. Reliance on the mental process grouping, distinguishing claims that recite a judicial exception from claims that merely involve a judicial exception, analysis of the claim as a whole, and consideration of whether a claim is directed to an improvement in the functioning of a computer or any other technology or technical field. There are multiple steps that the examiners go through when they're examining a patent application to determine if it's eligible for patenting. And step 2A has multiple prongs. Prong 1 is the prong where they determine whether an idea is included in one of the enumerated categories of abstract ideas, which are one of them includes the mental process grouping. And prong 2 is where they determine whether even if a claim is directed to one of those enumerated categories, whether it includes a practical application. Finally, there is another step to the analysis, step 2B, where the examiner is supposed to reconsider again the claim as a whole to determine whether it might include significantly more than any alleged abstract idea that's included in the claim. So what this memo first tells the examiners is that the mental process grouping is not without limits. Now, as a practitioner in the field, I often find that the examiners are raising the mental process grouping as the category that the claim is directed to, and it's sometimes hard to escape that analysis. And I think what the office is doing here with the memo is basically telling the examiners to back off a little bit on their categorization of certain claims as being included in the mental process grouping. So I think if we go back really far into the case law, what was meant is, originally anyway, in the case law, is that you can't patent a thought that you have. That's what that's where the mental process grouping kind of stems from, I think, is that the idea originally was you cannot patent a thought that you have. And many of our claims go far beyond just something that you're thinking about. And even though there is case law, obviously, that covers other things besides just thoughts that are included in this grouping, I think what the patent office is saying is let's not categorize everything as being a mental process. Also, the memo mentions that examiners should be careful to distinguish claims that recite an exception from claims that merely involve an exception. And that's kind of interesting because that's a subjective determination, which as a patent attorney, I will be arguing that your claims just involve one of these exceptions. They don't actually recite the exception. Looking at step 2A, prong 1, again, there's some examples given, and these examples are very important, I think, that are highlighted in the memo. With the subject matter eligibility guidance from the Patent Office, there are, I think, approximately 49 examples that demonstrate claims that are eligible for patenting or not eligible for patenting, and gives reasoning for how they were determined to be one or the other. And the memo highlights a particular example, which is very interesting. Example 39 of the examples that are included with the subject matter eligibility guidance. When the 2024 AI SME update came out, there was a question as to whether example 39 was still valid. This example 39 talks about training the neural network in a first stage using a first training set is one of the quoted elements in the memo. And what I find very interesting about the fact that they highlighted example 39 is they're basically saying this is an eligible claim still, even in view of the 2024 AI SME update, which gave other examples of types of machine learning that are eligible or not eligible. So they're highlighting this and they're saying that this particular element, training the neural network at a first stage using the first training set, is not abstract. And that's what the memo is reminding the examiners, and it's what's shown in the examples that come with the guidance. Now, this is where it gets very confusing, and this is part of why subject matter eligibility is such a huge problem with the way it's being done at the Patent Office today. There are about 80 pages of guidance in the MPEP, which is the Manual of Patent Examination Procedures. And those 80 pages just for subject matter eligibility. And so the examiners have a lot of difficulty understanding what they're supposed to be doing here. There's a lot of material for them to understand. And this example really highlights a problem with the way they're being trained, in my opinion. So you see example 39 just talks about training the neural network in a first stage using a first training set. That is not considered to be a mathematical concept. It's not considered to be directed to any of the enumerated categories. It's step 2A, prong 1, that particular element. Now contrast this with another example, claim 2 of example 47. This is what the memo is highlighting, by the way. Claim 2 of example 47 talks about training an algorithm using a backpropagation algorithm and a gradient descent algorithm. Now, as you can see, this contrasting example is far more specific with respect to the algorithms that are being used. Where we have example 39, we're just training the neural network in a first stage using a first training set. Here we have a very specific example of using certain algorithms that are recited in the claim. And this is where I just don't get the memo and why they highlighted these particular examples, because they're saying this far more specific recitation is a mathematical calculation and therefore not eligible, or at least directed to one of the enumerated categories of ineligible or abstract ideas, particularly a mathematical calculation. So this is a very confusing part, and I just wish that the USPTO had not used these two examples because they're not giving a good argument, in my opinion. When we're talking about the claims, usually more specificity is better, and they're giving an opposite example here to that concept. Now we're going to look at what the memo says about step 2A, prong 2, and this is where we're looking for a practical application in the claim. So the memo tells the examiners an important consideration in determining whether a claim improves technology or a technical field is the extent to which the claim covers a particular solution to a problem or a particular way to achieve a desired outcome, as opposed to merely claiming the idea. And again, the examiner is reminded to consult the specification to determine whether the disclosed invention improves technology or technical field. This is good, I think, because what we're finding with the case law when we get to the CAFC cases is that there must be a nexus between the claim language and the problem and the solution that's described in the specification. And that's one of the key ways to determine whether a claim is eligible for patenting or not. It's whether you've described with sufficient detail in the specification the technical solution to the technical problem, and you've claimed it, that particular, or claimed something that ties the claim language to that description that you have in the specification. So the memo is just basically reminding the examiners that's how we make the determination. That's how you determine whether there's a practical application or not. This is important language that I like to include in office action responses now. A lot of things can be quoted right out of this memo and used in office action responses when the examiner is rejecting a claim as allegedly failing step 2A, prong 2. That one important thing is examiners are cautioned not to oversimplify claim limitations and expand the application of the apply it consideration. This goes way back because the Alice decision is where things started to get complicated. In 2014, I believe, was when the Alice decision came out. Before that, when I was a practitioner in my first couple of years as a patent attorney, all we had to do to overcome a 101 rejection was add a processor to the claims. In other words, we tied it to hardware. And if you performed steps using a processor, that was usually sufficient to establish eligibility. But since the Alice decision, what happened in that case was there was a claim that dealt with intermediated settlement, which was a well-known problem and had been handled manually in the past. And all the claim did was apply a computer to solving the intermediated settlement issue. And that is not sufficient now, as of Alice, to establish eligibility. So the memo is basically telling the examiners, again, to back off a little bit on the claims and whether you're oversimplifying the claim limitations or not. Because what has happened since Alice, we had a claim that recited intermediate settlement applied on a computer. But now that same case is being used to reject claims that are way more specific, that do far more than just recite an abstract idea and apply it on a computer. So the memo is just telling examiners, kind of reminding them, I guess, that we can't oversimplify the claim limitations. This is very important language from the August 4 memo that I'm using in all my office action responses now. Examiners are reminded that if it is a close call as to whether a claim is eligible, they should only make a rejection when it is more likely than not that the claim is ineligible. I don't know if it's going to help much, but I'm using this in every response that I do. I'm arguing that we have a close call, and therefore there should not be a rejection raised. So this memo helps us a little bit. Let's get to the December 4 memos. There's two of them. The first one talks about subject matter eligibility declarations. And this is very interesting because you might know of certain cases, or I don't know how many of you encounter this or software experts, but the examiners are almost always raising, if you end up in certain art units, let's say 3,600, they're raising a subject matter eligibility rejection, and they're often sticking to it to the point where you cannot overcome through multiple rounds of prosecution, even with examiner interviews. You cannot persuade the examiner to withdraw the rejection. This gives an option that has not been, I've personally not used it yet, but I know some of my colleagues have started to investigate this, and we've started to, I think one or two clients of ours have actually filed these. They're memos where you can have an expert basically sign an affidavit saying that there is an improvement here that goes beyond the abstract idea, or that you have something significantly more than an abstract idea. And this may be a way, I think the Patent Office is reminding examiners that there's a way to use evidence to show that you have something that's eligible for patenting. And so they've issued this memo to just tell the examiners, look, there is a route that certain people may choose to take to establish evidence that their idea is eligible for patenting. People who can file these, any person who has knowledge of the facts being asserted in the declaration may sign the declaration. So an inventor, a co-worker of the inventor, an independent expert, these are examples of people who could sign an affidavit, and you could file this as evidence in support of your claim being eligible for patenting. So no special qualification other than knowledge of the facts is required. This is very interesting. Again, there's some guidance in the memo about what is sufficient for establishing evidence. And again, there must be a nexus between the invention as claimed and the evidence provided. And there's an example of a SMED may demonstrate how one of ordinary skill in the art would interpret a specification to show that the claimed invention is eligible. And to be a probative value, any objective evidence should be supported by actual proof. So this is just some of the requirements for a SMED. This is a very interesting point raised in the memo, which may or may not be accurate, actually. It says the specification need not explicitly set forth the improvement, so long as the specification describes the invention such that the improvement would be apparent to one of ordinary skill in the art. I think the standard is higher at the Federal Circuit. If you look at some of the recent case law, the court is looking at the specification to see if the actual solution and problem are being described sufficiently, and then checking the claims to see that the claims correspond or are tied to that description. Interesting that the memo kind of makes that a softer requirement here. The memo makes clear that the examiner must carefully consider all of the applicant's arguments and the evidence rebutting the subject matter eligibility rejection when evaluating the applicant's response. So the office is telling the examiners that they have to take these SMEDs seriously. If you have someone sign an affidavit that establishes that an expert thinks that this material is eligible for patenting, the examiner must consider that as evidence and must take it seriously. This is A great, I think, option potentially for those difficult cases where the examiner just is not backing off on the subject matter eligibility rejection. Before I get to this next part, there's a second memo. It's the best practices memo. There's not much to this memo, actually. But I think one of my colleagues raised an interesting point, and that's that with these SMEDs, you also have to be very careful about estoppel. You don't want to concede, or you don't want to establish or put in the record that a claim is more narrow than it actually is in its recitation. So the way that the affidavit is made has to be done very carefully, I think, to make sure you're not narrowing the subject matter through prosecution history estoppel. And so I would look, if you plan to do one of these SMEDs, there are some examples at the end of the first December 4 memo that show very specifically types of affidavits that work in certain cases. And so it's worth looking very closely at that memo at the end, especially those examples, to figure out what makes the most sense in your particular case. And you should be conscious of the estoppel issues that can arise. You don't want to characterize your claims as being narrower than they are. That's really one of the most important things to look at when you're doing a SMED. Now, this second memo, same day as the first memo regarding SMEDs, all this memo does is repeat a lot of the material from the first memo. And I actually took out the quotes that are used in this second memo and highlighted in the second memo. We've already gone over those now. But what it's telling here in this second memo is telling people that file a SMED to file them separately from any other declarations. That's all this is. The best practices memo is basically saying when you file a SMED, make it a separate filing. They give some reasons for this. Ensures clarity and relevance of the evidentiary record, facilitates examiner review and decision making, enhances the clarity and may bolster probative value of the SMED, and reduces risk of procedural or substantive confusion. You know that is a big problem with the 101 rejections right now, is examiners are conflating the 102 and 103 issues with the 101 issue. And the problem is, even back to the Alice decision, there was some conflating of these issues. 102 is whether a claim is anticipated or not by the prior art, and 103 is whether the claim is obvious in view of the prior art. So obviousness and anticipation are being mixed often into the 101 rejection, which is supposed to be just about eligibility of the subject matter, not whether the prior art teaches or suggests the elements. So they're trying to, I guess, make the point here that when you're talking about subject matter eligibility, let's not mix it with the other issues that are related to patentability. So that covers the December 4 memos. The timing of these memos is very interesting. The next day, the Patent Office released the December 5 memo. Now, the December 5 memo talks about the Desjardins case. And the Desjardins case was a very interesting and strange case. What happened was the commissioner for the Patent Office established a review by appeals board. It's called an ARP, and he is the only one who can make this appeals board. And he created this appeals board to review this one particular case and to reverse the appeal board with respect to this case. This case had to do with a software claim that was found to be ineligible by the appeal board, and the commissioner had it reversed by the ARP, the Appeals Review Panel. So there's some interesting things in this memo that I think help people that are seeking a software patent, potentially. And the memo goes over changes to the MPEP that have been made since the case in view of this reversal of the appeal board. Here's one of the paragraphs that is going to change in the MPEP after the Desjardins decision. I think we don't have to look specifically at the Desjardins decision because this is what the examiners are being taught in view of the Desjardins decision. And this is what we need to be aware of, I think, as far as what the examiners are being told. So this is a precedential decision. The claimed invention was a method of training a machine learning model on a series of tasks. By the way, this brings up an interesting point with the new direction that the Patent Office is taking with respect to AI. It started with the 2024 AI SME update. They want to make it easier for people to get patents on AI related technology so that the US can be competitive in this space. Obviously, if the examiners are rejecting AI related inventions under the 101 statute, we are going to lose out on potentially a lot of uh, patents that could be and should be determined to be eligible. So I think that's part of what this what this series of memos is dealing with here. So let's look particularly at what was talked about, what's being changed in the EPEP here. So the appeals review panel upheld the step 2A prong 1 finding that the claims recited an abstract idea. In other words, it was included in the mathematical concepts, which is an abstract idea. But at prong 2, the ARP determined that the specification identified improvements as to how the machine learning model itself operates, including training a machine learning model to learn new tasks while protecting knowledge about previous tasks to overcome the problem of catastrophic forgetting encountered in continual learning systems. So I think this is laying the groundwork for how an examiner is supposed to look at the cases. They're supposed to look at the specification. Let's see what the problem and the solution are that are being described, and then look to the claims to see if the limitations reflect that improvement that's described in the spec. So that's what is being changed in the MPEP. It's it's already been in the case law for quite some time, but this is just something that again the examiners are being told that they are supposed to be doing when they analyze a case or a claim to see if it's eligible for patenting. There are some additional sections. I know this is a big block of text here, but there's additional sections in the MPEP that are being changed. It's basically explaining why the ARP overturned the appeal board with respect to this decision in Desjardins to find eligible subject matter and trying to explain to the examiners here are some of the things that caused us to determine that the board was wrong in rejecting this claim. So with this information, the examiners should be changing their procedures slightly and looking at especially AI related inventions as being potentially eligible rather than ineligible. They are presumed to be ineligible by many art units right now, in my opinion, 3600 being an example. And I think that these memos are meant to kind of change the view of some of these examiners and some of these art units. Again, there's just another modification to the MPEP here to add the Ex Parte Desjardins case to the list of cases that support improvements to technology or a technical field. Now, I think it talks specifically about the technology, including data structure elements, reciting adjustments and values to a plurality of performance parameters while preserving prior values. So this is just like some specific information about the actual claim language that was found to be eligible for patenting. These are other sections that are revised, and you can look at these slides later. I don't want to go into too much detail here, but I did cover the most important sections, I think, that were changed in the MPEP as a result of the ARP overturning the appeal board in the Desjardins case. Again, it's a training of a machine learning model considered to be eligible for patenting. Okay. The next part of the presentation, I'm going to briefly go over some of the case law updates since Berkheimer. If there are any questions about the memos, you could put those in here in the chat as well, and I could try to get to those. So since Berkheimer, this is 2019, there are 39 cases finding ineligibility and 21 cases finding eligibility. Now, of those cases that were found eligibility, only 16 pertain to software. Now, of those 16, 11 were found to be not abstract, and 5 were found to be have an inventive concept. This is very interesting data. First of all, it shows what you're up against if you take a case to the federal circuit. You're probably going to lose more than half of those cases. Also, something I find to be very interesting about these statistics, the decision of whether the claim was eligible or not was made at step 1 in 2/3 of the cases. And that is contrary to what you will find when you're filing a patent application and having an examiner review it. Examiners will almost always find at step 2A, prong 1, that your claim is directed to one of the abstract concepts. That the only chance, usually, when you're prosecuting an application with an examiner at the patent office, is to succeed at the second step. In other words, you need to show a improvement, basically a practical application at step 2A, prong 2, or that you have something significantly more than the alleged abstract idea at step 2B. Now, if that's the case, we have the patent office dealing with the claims in a certain way that's slightly different than what the federal circuit is doing. Unfortunately, that leaves us with only 5 cases that are helpful out of all the cases that have been decided since Berkheimer. This is a problem because the examiners are obviously finding too many cases to be directed to one of the enumerated categories of abstract ideas at step 2A, prong 1, and it's almost impossible for a practitioner to persuade them otherwise. And that's different than what the Federal Circuit is doing here. The Federal Circuit is finding eligibility at the first step most of the time. I have a list of cases here, and I think it's important to go through them. So these are the cases where claims were found to be eligible since Berkheimer, and it covers at which step they were found to be eligible and what the technology related to. So I think this is important to look at. Atrix is the first one on the list here. Here's where an inventive concept was found, even though the claims were directed to an alleged abstract idea, and this related to importing data into forms. So here's a great example of a software application revolving around importing data into forms, and there was an inventive concept found. That's good. That's good news for people that are seeking software patents. Now let's look at things that were found to be not abstract. A tab interface for 3D spreadsheets. That's just simply not abstract. Software licensing, software license control using a BIOS. Now that makes more sense to me that it's not abstract. We're dealing with a BIOS. It's a low-level operating system. SRI International found evaluating network data to find suspicious activity to be not abstract. That's important because there are many cases that I deal with that involve network data, security type related software inventions, and this is a good sign that this was found to be not abstract by the Federal Circuit. Self-spin, data transfer between devices, inventive concept found. This is where it's so important to describe what it is that you're solving as far as a technical solution to a technical problem in the spec and tying it to the claim language. It just shows that you can get a claim still today on data transfer between devices. More that were not abstract. Error checking in data. Cardiac monitoring device makes a lot of sense that would not be abstract. Communication station, not abstract. These are kind of physical devices. Okay, identifying disjointed network connection flow. not abstract. Improved lab technique for sorting particles, not abstract. Encryption method that improved network security, not abstract. Authenticating users at a terminal. This was found to have an inventive concept, and we're going to go into this case in a little more detail. Peer-to-peer file sharing, inventive concept found. Recording physical movements and using data for electronic searches, inventive concept found. Encoding serial number in an RFID chip, not abstract. Cameras that streamed low quality image stream for live camera control, not abstract. And then this last one, polycrystalline diamond compacts claimed with limitations related to magnetic properties. That's obviously not abstract. And then finally, I just put the Desjardins decision here because it was considered to be an important case. And it's a method for training a machine learning model, not abstract. Now, these are all the cases that we have since Berkheimer that can help us with an examiner rejection. Now, again, the problem is that the examiners are never, almost never, backing off from the prong one analysis, a step 2A prong one, where they find a claim to be abstract and leaving us to only argue that we have a practical application. So there's only those 5 cases where an inventive concept was found that are helpful. I asked ChatGPT to look at these cases and figure out what do the non-abstract cases have in common. And this is what I got. Of course, you have to take everything that ChatGPT says with a grain of salt, but this is what it said. They each specify a particular mechanism, structure, or technique rather than a desired outcome. They each operate on or within the technology itself rather than using technology as a tool for a non-technological task. They each respond to a limitation that is specific to the technology, and none of them are primarily characterized as collecting, analyzing, and displaying data. That's an important one because this always comes up, and it's a problem with software inventions in particular because the claims often involve collecting, analyzing, and displaying data. Now, as a patent attorney, I've started to modify the way that I draft the claims to not simply specify collecting, analyzing, displaying data, but to go further. But it's tricky because this is a problem with many of the cases that are found to be ineligible, is the order of the steps tends to be this for a lot of different software applications. Now, here's the more important one, because this is where we are more likely to be able to persuade the examiner that we have an eligible application. And it's at step 2A, prog 2, where we're trying to show the inventive concept. So I asked ChatGPT, what do the cases found to have an inventive concept have in common? The inventive concept resided in a non-conventional arrangement or combination of known elements rather than in a single novel component. So that's interesting. The claimed combination provided a technical benefit distinguishable from the abstract idea. The inventive concept was tied to specific claim limitations rather than unclaimed specification disclosures. And the cases, this is not relevant to us, though. The cases frequently arose at the Rule 12 stage, where factual questions about conventionality remained open. This is usually not an issue for us, but we do have the SMEDs now. So the SMEDs are a way to establish evidence, but it's not a Rule 12 stage because this would happen during litigation. But this is just an interesting encapsulation of what we have to work with here when we're talking to an examiner in view of the case law, and we're dealing with step 2A, prong 2, which is trying to show a practical application. Now I'm going to get into some specific cases, and one that's related to a case that I was recently dealing with for a client. We're going to look at a patent eligible case here. This is the actual claim of the Ancora case. And the Ancora case talked about a method of restricting software operation within a license in a memory area of a BIOS of a computer. And these are the steps that were found to be eligible and actually not even abstract, just this eligible, and decided that step 2A prong 1 is not abstract. So the steps are pretty basic. Selecting a program residing in memory, using an agent to set up a verification structure in the erasable non-volatile memory, verifying the program using at least one verification structure, acting on the program according to the verification. That is considered to be a not abstract claim. And that to me is crazy that this is not even considered to be abstract. So at step one, the court found the claims were not directed to an abstract idea. The invention related to operating software within the limits of a software license. Let's see. So they found that the case focused on a solution to a computer functionality problem. The proposed technique departed from earlier approaches, which, when you look at that claim, I am surprised that they thought that. Okay, and because the claims were found to be patent eligible at step one, not directed to an abstract idea, the court did not evaluate step two. There was no reason to even check to see if there was a practical application because the court determined this is not abstract. They related it to Enfish and McRow, which are two favorable cases. Now let's look at Universal Secure Registry. This is another one of the cases that was found. Sorry, this case I think was found to be ineligible, and it's important to distinguish it from the other ones. Okay, so at step one, the court determined that this particular code-related software application was related to a known abstract concept. They dealt with, this is during litigation, so they dealt with the patent owner's counter argument that this particular element of time-varying multi-character code was a specific technique. Here's what the claim looked like. This is the actual claim. So the claim related to providing information to a provider to enable transactions between the provider and entities who have secure data stored in a secure registry. The steps involved a receiving step, a mapping step, a determining step, an accessing step, a providing step, and an enabling step. The court looked to see whether there was a practical application and determined that there was not one. They viewed it as similar to Alice, which is where the intermediary in Alice facilitated settlement between parties, and they compared the code of the claim as being analogous to that case. So the one-type code was performing the same type of function, mediating a transaction, and therefore could not rescue the claim. So we've got one that's eligible, which used much broader language, in my opinion, and one that's ineligible that had very specific language around the types of data that were used and the one-time code and various other factors that related to this. Now we're getting to a third case, and this is where we find an eligible case, which deals with almost the exact same subject matter as the previous case. So here we have a method of authenticating a user to a transaction at a terminal, and the steps involve transmitting a user identification, providing an authentication step as a criterion to deciding whether to authenticate the transaction, having a device check whether a predetermined time relation exists, ensuring the authentication function is normally inactive and is activated by the user only preliminarily, ensuring that the response includes information that the function is active, and thereafter ensuring that the authentication function is automatically deactivated. So this case also dealt with a security transaction at a terminal, just like the previous case. The language is more broad than the previous case, but the court found this one to be eligible for patenting. So this is where all the confusion with 101 stems. For examiners and practitioners, is these cases are almost indistinguishable from each other, in my opinion. And one is found eligible, the other is not eligible for patenting. And in fact, I would say they got the opposite answer of what they should have come to. But again, it comes down to the facts, the very specific facts of what is included in the specification versus what is claimed. And often, if you've described in the specification the technological problem and the technological solution clearly, and then your claims tie back to that, the claim should be found eligible for patenting. And that may be why you see a much broader claim here being found to be eligible for patenting versus a narrower claim being found ineligible for patenting. So in particular, here's where the courts came to the answer at step one that the claim that we just looked at was not abstract. They didn't even look at the second step because they just determined this claim is not abstract. So this is the mess we're in right now with all the different case law, the guidance, and all this inconsistent decisions that we're dealing with. And you even have the judge in this case saying the court made a mistake by not looking at step two. Step prong. Okay, there's also something else we need to clarify here. The guidance does not align exactly with the Federal Circuit case law. Step 2A, prong 1, is whether something is directed to one of the enumerated categories of abstract ideas according to the Patent Office. That aligns with Mayo Step 1, Alice Mayo Step 1, that the Federal Circuit is using, where they make the same kind of determination. Now, Step 2A, prong 2, which is where you look for the practical application, sort of relates to Mayo Alice Step 2, which the Federal Circuit is looking at in its decisions. But Step 2B of the Patent Office guidance is more aligned with the Step 2 Mayo Alice Federal Circuit case law. So this is where another huge problem arises where the guidance does not exactly align with the Federal Circuit. So it's kind of hard to figure out how to map everything together. The court actually looked at the differences between the two cases. So when it really determined that the CosmoKey claim was eligible, it tried to distinguish the claim from the previous case. And this is how they did it. The court distinguished Universal Secure Registry, noting that Universal Secure Registry related to combining conventional authentication techniques to achieve only the expected result of the combination. In contrast, the court found the CosmoKey case more similar to Ancora, which is the memory case that we first talked about, where verification methods that departed from earlier approaches were directed to non-abstract computer functionality improvement. So that's their reasoning, and I'll leave it to you to figure out if that makes any sense whatsoever. I want to show you a claim from a case that I personally dealt with the Patent Office in the same space as CosmoKey and Universal Secure Registry. Here are the elements of a claim that I submitted on behalf of a client for this is application number 12856026. The method involved performing operations within a computer implemented authentication architecture to authenticate an identity of a user before allowing or denying a request from the user to authorize a credit transaction. First, establish an authentication account, receive authentication information, receive a set of renewal rules, and the renewal rules specifying various information, storing the one or more conditions in one or more profiles, and then in response to receiving a request from the user to authorize the transaction, determining whether the user has been validated. Okay. This claim, I went back and forth with the examiner for years, trying to get it allowed. We finally appealed the case. We cited Universal Secure Registry and CosmoKey, drawing a careful analogy to CosmoKey, which is the favorable case. The board came down with a decision after we appealed it. The board's decision didn't even cite any of the cases, didn't look at any of the arguments that were made, and just rejected the claim as being ineligible for patenting with a very sparse analysis, without even looking at the arguments made by the examiner or my client. We filed a request for rehearing because the decision was so atrocious. The board denied our request for rehearing and then cited some of the case law that we had previously cited to and claimed that our case was more like the Universal Secure Registry case than the CosmoKey case. It's very, very ridiculous stuff that happened here. My client decided not to appeal to the Federal Circuit, but it's just an example of where you end up even when you go to the highest levels with a board request for rehearing, you will lose a case where you're clearly in the right, in my opinion. So this claim, I would like for everyone to take a look at this claim and see whether it's more like Universal Secure Registry or more like the favorable case, CosmoKey. And I think the answer can only be one answer, and the patent office got it wrong. Okay. Um, I think that's pretty much it for this presentation. I do have more slides that you can go through here, dealing with the CosmoKey and the Universal Secure Registry case and this appeal that I took up on behalf of the client. I see there's a question here from Anthony. Assuming that your client uses generic computer components, like most do, what would you say are the best practices for a software processor case to avoid the examiner finding an abstract idea? Is it merely to state a technological problem and solution, or is there something else? How would you suggest handling ideas that are primarily user-based, e.g. QTech or InnovaPort? Okay, let's see. I think, we have a boilerplate often in our applications that show the computer. And within the boilerplate, there is a set of instructions. And as long as that set of instructions is tied to the novel elements, including the operations that are being performed, that are described in the specification, and as long as there is a technological problem and a technological solution described in the specification that that method or those operations address, that's the key. So I think even when we have these generic, so-called generic computer components, they aren't really generic because they include instructions. And inside those instructions are where the novelty lies. I do think sometimes the boilerplate needs to be updated to make it clear that although some of the computer components are well known, the set of instructions that are being executed are not. And that's where the big distinction lies. I've gone so far as to actually modify some of my language in the boilerplate to specify that this is a non-conventional, like just make the assertion that this is a non-conventional set of instructions that's being performed by the hardware. I think it's important to establish or at least make an assertion that what you're dealing with is not well-known, routine, or conventional, right? That's the test at step 2B in the USPTO's guidance. And so I like to make an assertion now, but still, it shouldn't matter that there's so-called generic computer components being used because of the instructions that are being executed. You said something about handling cases that are primarily user-based. Well, it shouldn't matter if it's user-based or not, because the technology usually has a server-side component, which is where usually you'll focus your claims, although it could be on the client as well. I'm not sure, Tony. I think I'm not sure about that last part there. And I'm not familiar with QTech or in NovaPort either. All right. If there aren't, I think we're done unless we have any more questions. We have about 5 more minutes left. Does anyone have any other questions? Okay, you mentioned the use of the 132 affidavits. Do you have any info about how they're shaken out? No, I don't have info. It's such a brand new idea to contemplate for most of us. I've never filed one. I know a couple of my colleagues have filed, um, but we don't have results yet, I don't think. But I do think it's an important consideration that we can now do this. Well, now the patent office has told the examiners that we might be doing this. So I think I actually plan to use these. I have a few difficult cases right now, and I'm going to have my inventors or someone familiar. Remember, it doesn't have to be the inventor, it's someone who's familiar with the facts of the case, who's an expert potentially. I am going to have them file an affidavit. Seriously, I think this is the next step. Remember, the big concern with the affidavits, though, is creating estoppel. You do not want to characterize your claims as being more narrow than they are. Everything in the affidavit will be on the record. So that's the tricky part. And I plan to look at the memo, the first December memo, There's some very specific examples given at the end of that memo that can provide the guidance that we will need as attorneys to prepare the proper affidavit in particular cases. So I do think this could be a big step forward, an option at least to advance those cases that are very difficult. Someone asked, should SMEDs be introduced only after final? Um, I don't think that's a good question though. You have to look carefully at the timing of when the SMED can be filed, and there are some very specific rules around when it can be filed. I think it doesn't have to be after final. I think it can be during any time during prosecution, but I could be wrong about that. I'd have to look very specifically at what those rules are. And the examiners are being told to make sure the rules regarding timing are being followed. So that's important to make sure you're following all the rules regarding the timing of when you file that. All right, I think we're done. Michelle, are you there?
Yep, sure am. Great job, Kirt, and thank you for joining us, everyone. Please join us for future SLW Institute webinars. Next Thursday is episode 1 of the SLW Quantum Computing webinar mini-series when Laura Konitsky presents a practical guide to quantum technology for patent practitioners, moderated by Matt Norwood. And coming up also is the next episode of the SLW Chemistry and Biology webinar series when Trevor Lind presents Legal Frameworks for AI in Life Sciences, Patent Law's Adaptation to Technological Innovation, moderated by Nicholas Lancetella. So please keep an eye out for those upcoming webinars in your email and LinkedIn. So thanks again, everyone, for joining us, and take care and be well.